The topic of this video is precedent. Now, before I actually dive into the topic itself, I want to start off with mentioning a couple of key resources. They are both website resources. Now, can I first begin with Neil Powell's The Law Bank? Now, the Law Bank is a phenomenal website. I'm not getting commission for it, okay, so don't be thinking that. Seriously, I've taken a look at the website, I've navigated it, I've met Neil Powell. I'm highly impressed with him, and his information is accurate, it's very knowledgeable, and if you subscribe to it, you're not going to need a law textbook. Alongside our resources and the Law Bank, you're going to have more than you need. So Neil Powell's The Law Bank, it has a yearly subscription of £35. You can pay me later, Neil. No, I'm only joking. And the second website that I want to recommend is the AQA website. Now, though the information that I'm going to cover can be OCR applicable, we are covering AQA law, so it's more geared towards the AQA syllabus. Now, I will say a lot more about the AQA website later, but what I would say is that one of the things that we're going to focus on this year is to get you to become self-directed learners. In other words, independent learners. Be able to navigate your own learning, be able to assess your own learning, and the AQA website is going to be highly crucial in order to do this. Okay, whenever we start a new topic, the first question that I'm going to ask you is, where are we headed? In other words, what's the destination and what do we need to pack in order to be ready for this particular journey? There are a number of key features and key components for each topic that are relevant for that topic. So the best way to start is to see the big picture, see all the components, and know that once you have covered each of those components, you're ready for an exam question on that particular topic. So that's where we're going to start, with the big picture. Okay, so when you look at the big picture diagram, you'll see that we're going to start with the definition. There'll be some coverage of the court hierarchy, not a great deal, but a brief overview. We'll look at some of the operation of precedent, the key components that helps it to operate effectively, and the importance of law reports. Disadvantages and advantages will not be covered in this video. Let's start off with a good definition of precedent, and it's important that you know your definitions for each of our topics. So what is judicial precedent? Well, it's the term given to decisions made by judges in legal cases. Now, when a judge makes a decision, it's called a judgment. In a first of its kind case, these judgments create laws for later judges to follow, so long as the facts of that case are similar to the earlier case in which the first decision was made. Okay, let's think back to the big picture diagram. Now, the first component on the big picture diagram is that we understand what precedent is. So we've got to familiarise ourselves with a good definition of precedent. So what is precedent? Judicial precedent is the term given to decisions made by judges in legal cases. So when a judge makes a decision, it's called a judgment. In a first of its kind case, these judgments create laws for later judges to follow, so long as the facts of that case are similar to the earlier case in which the first decision was made. Okay, so remember that, that's your first bit of information. So your first little component of information is the definition. Judicial precedent is the term given to decisions made by judges in legal cases, and in future similar subsequent cases, those decisions are used, and this creates certainty in the law, so it's a very important feature. Okay, so leading on from the definition of judicial precedent, this is going to be perfect timing to introduce you to the fact that there are going to be a number of Latin phrases that you are going to need to learn for this topic. Now, one of those is the Latin phrase stare decisis. I love the sound of it, stare decisis. Now, stare decisis translates to mean lets the decision stand. In other words, once a legal decision has been made in one case, for the sake of certainty and clarity, it's fair and just to stay with the same decision for all future similar cases. So that Latin term again, stare decisis, and you're going to need to have to remember this. Now we're going to move on to next, the second component. So from the definition of precedent, we now need to move on to the actual court hierarchy, and it's important that you understand the court hierarchy. So that's what we're going to do next. Okay, so the next key component after the definition is that we are familiar with the court structure. Now, the courts in England and Wales have a clear order or hierarchy. You'll find that the Supreme Court is at the top of the court structure, and the position of a court in the court hierarchy is very important in our understanding of judicial precedent, how it operates. The more senior a court is, the more likely it is that its decision will create a binding precedent that the courts below it will have to follow. So let's take a look at this in a diagrammatical format next. So I'm going to introduce you to two more Latin terms. Now, the first Latin term that I'm going to introduce you to is called ratio decidendi. Now, ratio decidendi means the reason for the decision. So it's the legal reason behind the decision in the case judgment. Now, once a case has been heard and the judge has considered the arguments put forward by the lawyers, the judge will then consider those arguments and then arrive at a judgment. He or she will go on to explain the legal reason behind their decision. So the ratio decidendi is a very important feature in the operation of precedent. It has got to be followed in future similar cases by the same court who created the precedent as well as courts below it. Way or other things said. Judges in their judgments will explain, as you now know, the reason for the decision, so the ratio decidendi. They may also say other things. So, for example, they may say, if the facts had been different or if they had been like this, this would have been our reason. So they're hypothetical examples. Obiter dicta is a persuasive precedent, whether the ratio decidendi is a binding precedent that must be followed. Now, if a judge follows the obiter dicta of a particular case in a later case, it becomes the reason for the decision of that later case. Key cases to look at would be cases such as Howe, H-O-W-E, and the obiter dicta in Howe was used in the case of Gotts that followed, because the information or the facts in Gotts were a little bit different to those in Howe. So the persuasive precedent, the obiter dicta from Howe, was used in Gotts and then became the reason for the decision in Gotts. And you'll find the same with R versus Brown. Now in R versus Brown, the obiter dicta in that case was used in the case of Wilson that followed and then became the reason for the decision in the case of Wilson. And we will have a look at this in a little bit more detail. So far you've been introduced to stare decisis, the Latin term that means let the decision stand. I had a moment where I completely forgot, my mind just went blank, it happens. And then the second Latin term that you've been introduced to has been reason for the decision, and the third Latin term that you've been introduced to so far in this presentation is obiter dicta, other things. To clarify next is binding precedents and persuasive precedents. And so far you've heard both those terms quite a few times now, so I'm going to clarify those. Now, binding precedent is one that must be followed. So ratio decidendi is a binding precedent, so it must be followed, or it's binding on all courts at the same level and below. A persuasive precedent is one that may be followed. Obiter dicta is a persuasive precedent. Now, other than obiter dicta, there are other persuasive precedents. For example, decisions made in other countries may be persuasive precedents for us, and decisions made by the Privy Council can be a persuasive precedent, as well as dissenting judgments.